Welcome to the Divorce Matters Podcast, where we teach you how to survive the family court system. We will give you no-nonsense, straightforward strategies for getting you an equitable outcome. We guarantee you won't hear this advice anywhere else. A reminder that we are not attorneys and this is not legal advice. However, we will help you more than any attorney ever will. And now, here's your hosts, Michael Alexander and Mark Fidelman.
Hello, everyone. Welcome to Divorce Matters. Today, and again, I should note there's a couple things that I want to talk about before we jump in. Michael won't be joining us, but I do have Carnell Smith that we're going to talk about in just a second. I am asking those of you listening for any whistleblowers, if you are one or if you know of one that is in the family court system, because we know it's corrupt. There are some good players in it. We know there's people that are trying to change it from within, but we also know there's corruption, and we'd love to hear from you. So that's my first order of business before we jump in. The second is I have a very special guest today. His name is Carnell Smith. He has gone all the way to the U.S. Supreme Court for his case. It's quite the story. We're going to focus on his story, but also some learnings along the way in terms of paternity, establishing paternity, protecting paternity, not getting screwed in paternity. So before we jump into that, Carnell, can you give us a brief background on yourself?
Sure thing, Mark. Thanks for the opportunity to be on Divorce Matters. So I'm Carnell Smith, the paternity coach. I help women, men, and families addressing issues with family identity by using DNA, law, and advocacy. So myself, I found out after 11 years of paying child support voluntarily, like you want the good guy to do, I found out that the child was not mine and that her mother had a secret. And I fought it all the way through the courts, end up having to change the law to get set free.
Now, come on, Carnell, that stuff doesn't happen. You're not the father. You've been paying child support for 11 years and you had to fight for you to get off child support. That doesn't happen in the U.S., does it?
It does happen in the U.S. In fact, Mark, from the data that we have from the American Association of Blood Banks, their annual relationship and parentage study shows that roughly 30% of the men and boys who get tested for paternity turn out to not be related to the child that was tested. And sadly, we can't find where 100% of them have been freed and let go. So for men and boys in this situation, you're facing jail and prison. And if you ever owe more than $2,500 in arrears, you can be convicted on a third-degree felony for child abandonment.
When I first heard your story, because we've talked before, I was in shock, a little naive at the time, still probably naive as to everything that's going on behind the scenes. So let's start from the beginning. A girl that you had been seeing had started...
Dated for 2.5 years.
Okay. And then there was a point when she got pregnant. So why don't you take it from there?
Let's jump in right there. So we dated for 2.5 years. I broke up with her. We had a disagreement over some things she said to me, and I felt, well, my position was I don't have to take this. So goodbye. About 3 months later, she said 7 words that no man wants to hear from his ex-girlfriend or his ex-wife. I'm pregnant and you're the father.
We laughed.
Yeah, it's funny, but I asked her, I'm like, okay, I haven't seen you. And then she says, well, you do remember Valentine's Day, right? Because I broke up with her the day after Valentine's Day. And she said, that's when I got pregnant. And since I knew that I was a participant, Mark, I figured that the Trojan man had failed me. And I said, well, look, I'll take care of my child, but don't think this is going to get you and I back into a relationship. Okay, I'll take care of my child. And I said, are you sure she's mine? She's like, absolutely. And Mark, there led the journey to me discovering what paternity fraud is and why I end up writing the book on Trapped by Law, how to stop paying child support for paternity fraud.
Okay, so let's walk through what you should have done differently. What happened, and then what you should have done differently. The day she said she was pregnant, and
Yeah.
you're the father.
Yes.
Now, there's probably not much, you probably can't get a paternity test at that point, but walk us through, if those of us, and not me, I haven't been in the situation, but I know there's plenty of people that have. Walk us through what should happen.
So just before you take any great comfort in your own position, if you look at my YouTube channel on Paternity Coach, you'll see most of those are married men that this same thing happens to. So what I should have done differently is, number one, I should absolutely have not relied upon a verbal claim from the ex-girlfriend. I should have required proof. And the only acceptable proof is a DNA test, not a blood group test, a DNA test, which in these days, currently the technology has advanced to where you can actually get genetic testing done while the mother is carrying the baby so that you can know before delivery. Back in the 80s, when the child was born, I was unaware. And back then they didn't even offer the prenatal testing. So the strategic best approach is, number one, do not sign an admission of paternity, which is a symbol of signing a confession without proof. So don't sign the confession. Two, get a legal paternity test. Wait till you have the results in your hand. If the results say 0%, you should say goodbye to her and tell her to pursue every other discussion with her child's father. If the results are 99.9% or higher, like when I tested my own daughter with my wife, it was over 99.999999. We're talking like 1 in a billion. Hey, I'm the dad. And that gives the guy the peace of mind of knowing that what happened to Carnell Smith won't happen to him.
Okay, so let's move the ball a little bit more forward, because your story gets really interesting really fast. So she has the child. How does she establish paternity for you and then subsequently child support?
Well, in case you're not aware, the hospitals are participants and partners with the Child Support Enforcement Agency. And there is this process whereby you get men and boys to sign a document. They refer to it as a voluntary acknowledgement of paternity. I like to refer to it as emotional swindle to get you to sign a confession without proof. And Mark, the technique goes this way. You get him to come to the hospital while the baby's there and the mother's there. You hand him the baby, and then you convince him how much that baby resembles him. Your eyes, your nose, your mouth, your features. Look, got your smile. Got the dimples that you have. And here, sign here, because you do want your baby to have a father. Now, Mark, in that moment, most men and boys are emotionally disarmed, and they are not thinking of a 18 to 21 year financial liability that could put him in jail or prison. He hasn't stopped to get legal advice, where you get the best time for attorney who can help you the most is before you find yourself in the trap, where you could get a consultation and advice and say, okay, here's what's been presented to me. Here's my best option. And if you're pro se, a pro per litigant, we're representing yourself, still become informed and educated and know that if you sign that document now, since about the 1990s, signing that document can waive your right to a DNA test later, which means you won't have an ability to refute that you're not the father, even if the mother tells you to your face, little Susie and little Johnny's not yours.
Wow. I mean, and if you do sign that document, what rights have you signed away? And is that the first step in establishing a child support situation? So
that's one of the steps in establishing child support enforcement. It is part of the federal Social Security program, Title 4D, Section 458, where the bonuses and incentive payments are created for payment to the states. And one of the metrics for the states is the number of paternities they get established and improve that year over year. So let's break that down. By any means necessary, if you can get the guy to sign up, without him taking the test, which means they don't have to reimburse the state for the DNA testing, he is now legally enforceable of obligation to pay child support with zero parenting time, has no ability to see the child, but you become 100% obligated to pay child support once you sign that document. Now, in my case, it never reached court because I voluntarily took care of the child, saying, well, we don't need to go to court. I mean, if she's mine, okay, all right, I'm going to take care of her. And I put the child on my benefits. I paid child support directly to the mother. I paid for music lessons, and I was involved, Dad. I was at the school, dentist, all of that stuff. But isn't that what we want? Look, when they say they want dads to step up, isn't that what we want dads to do? We want them to be involved so they can be active, guiding influence and a hand in the rearing and mentoring of the child. Unfortunately, the law doesn't require the mother to say and disclose to you. There's one or more people who could also be the child's father because I was intimately involved with those other people during the window of conception.
Support for this podcast comes from KidsMatter.Charity, a nonprofit dedicated to fighting for kids' rights in difficult divorce situations. Donate at KidsMatter.Charity to help them restore common sense to the family courts.
All right. So, Carnell, all of these things at the time she's not required to disclose she had other lovers. I mean, I could understand that, but I mean, if there's a question of paternity, I think she should have an obligation of saying, well, it may not be yours. But to be smart and to be legal, you as a man, you should be questioning it no matter what, whether there's disclosure or not. Is that correct?
Whether it was a one-night stand or a multi-year relationship, ex-fiance, ex-wife, Carnell's position is, as the guy, as a man or a boy, you should always confirm the facts with a legal DNA test so that you have results in your hand now that you can use should you need to take a next legal step.
Let's keep moving forward. So you didn't do all that. We know that. You've told everyone what they need to do. How did they get the child support payments going?
Well, as I said, is that I had voluntarily paid the mother child support for those 11 years. But listen, there's a point that changed. After she got married, after she bought a bigger house, she moved about 20 miles away. She calls me up and says, I've been talking to my girlfriends and you don't pay me enough child support. And I said, wait a minute. I pay you child support. I pay for my son's child support. I pay money into a college fund for what I believe was our daughter. And I maintain a separate wardrobe for her at my house and additional expenses whenever she's with me. And at that time, Mark, I had unlimited parenting time with very little hassles from her mother. But at that discussion, she made a demand to me. It was her way or no way. And I said, no, you're not. I've been bullied as a kid. And then once I've grown up as an adult, I don't take too kindly to being threatened, bullied, or given ultimatums. So she sued me for more child support. And that ultimately led to the court awarding her roughly 40% of my net income, while I'm the sole income earner. My wife is taking maternity leave. My new baby with my wife after 8 years is due any day. And as soon as I saw what that order was going to be for 40%, man, I'm like, I can't contribute to a college fund. In fact, I am going to lose my house.
Wow. And how did they establish that 40%? Was there guidelines or did they break the guidelines and make it up?
Well, back in those days, Mark, my state used to calculate the child support based on your gross salary.
Gross, not in your adding in your expenses and
Nope.
the fact you're married or have other kids.
Nope. They would barely deduct for the child support that I was paying for my son. So back then there was no self-support reserve for the other people in your household. Obviously, if I have myself, a wife, and then maybe a month after she sued me, a newborn daughter, hey, I have a 3-person household that I'm responsible for. Well, the wife and daughter don't get you any credit. They may as well kick rocks. And the court's position and the mother's position is, well, it's your fault that you had additional kids.
Wow. Okay. Yeah. Now, at some point, you like, maybe it's after this new award, you're like, how do I know this is my child or not? And then take it from there.
So what happened, Mark, is that I went to my pastor's dad because I used to have such after that court award happened. One of the first things that happened was my parenting time got cut. I went from unlimited parenting time to once every other week and once every other weekend. And the judge stipulated that if I didn't get there by 6 p.m., I forfeited the time. And I had to drive through 3 expressways to get there. So after all of that onerous burden, then the mother started interfering with me being able to pick up the child on my court-ordered days. So I would ask guys to go with me. I would take off-duty police officers, probation officers, anyone. I'd pay people to go with me to make sure that I was not going to have any problems. And one day on our way to pick up the child, my pastor's dad saw a billboard that said, "Who's the father?" And he said, "You need to get a paternity test." And he told me about what he had witnessed happen to military men while he was in the Air Force. And I expected to take that test and prove to him that this was my child. I got those results back about 2 days before my wedding anniversary, and I was stunned into silence as if somebody had punched me in the gut. 0.0% paternity. And then my world changed.
Okay. So let's just keep going because I think it's pretty obvious what the reaction most of us are having at this point. Let's keep going now.
Okay.
You would think that the courts would see that and they'd be like, okay, child support's over and you should refund all of it back to Carnell because she committed a fraud. But that's not what happened, is it?
No, that's not what happened. It took me several hours to get over that because I felt like I had a child die in my arms because I was like, this is going to change everything. But one thing's for sure, I am certainly not going to agree to 40% of net income, pay or go to jail for a pregnancy that we can prove I didn't commit. And that means someone else did. I mean, we let people go who've been falsely accused of murder, falsely accused of rape, falsely accused of sexual assault based on DNA evidence proving the accused or the convicted is not the right party. So I approached the court with sworn deposition of the mother admitting that she knowingly and willingly withheld the information about the guy who she had been involved with 6 weeks after I broke up with her. And then I subpoenaed her mom, her other relatives and girlfriend. And only then was I able to stitch together the whole story that she actually got pregnant 6 weeks after I broke up with her with the guy in the adjacent state. Now, we present all this information to the court. I sue for fraud. I sue for recovery of damages for the child support paid, my legal fees, and loss of use of my money. Because at this point, that represents the same thing the state would do to me if I hadn't paid child support for 11 years. The judge makes one ruling after a while and says, well, even though we have state law that says while I'm under a temporary order, if I find something defective with the order, you could challenge it within 1 year. And I was within the time frame. The judge said it was my fault. I didn't find out sooner and refused to overturn that order.
What's that judge's name?
The late Judge Edwin Wheeler.
Okay.
But listen, that same judge came back and admitted he was wrong.
Okay. All right. Because we name names on this podcast because I'm tired of these actors hiding behind this veil of judicial immunity. Yeah. We could call them out in the court of public opinion, and we're going to. But keep going.
All right. So I'm fully versed now in the legal research. Now I find that there's even precedent of case law in the state of Georgia of Paul Smith versus the state. And this guy and I might turn out to be related. Well, guess what? His story is very similar to mine, and he found out that his ex-girlfriend snookered him and one of 2 kids was not his. And they reduced his child support based on the fraud. And that allowed him to be able to survive after that. So I appealed to the Georgia Court of Appeals, petition denied. I appealed to the Georgia Supreme Court with the data of all of the men that I found out in the state of Georgia from the state contracted lab, and over 90,000 guys had been tested. Over 30,000 turned out to not be the fathers. And the Supreme Court of Georgia said petition denied. Well, now at the same time, Mark, I am lobbying for new legislation here because I believe that any man or boy who's trapped in this situation shouldn't be left up to judicial discretion. I mean, the judge shouldn't be able to look at the evidence and the testimony and just entirely discard the whole thing. And my state representative turned out to be in my neighborhood, Mark, and eventually we got that legislation passed just before I got my case to the U.S. Supreme Court. The U.S. Supreme Court required me to divulge that information and then required me to send a supplemental brief because I challenged the order on constitutional grounds that you are, in effect, you are turning the man who is not related to the child, who didn't adopt a child, you're turning him into a slave for involuntary servitude because his wages are now being taken under the threat of loss of liberty to become a state hostage, to be counted toward the state metrics for child support enforcement. Well, Mark, they get my supplemental brief and the U.S. Supreme Court sends me the same line, petition denied.
What?
At this point, Mark, I've shown the highest court in the land. There's over 1 million men and boys that we know of tested, turn out to not be the dads, and we can't find information where 100% of them have been set free. Now, Mark, you would think at this point, if you've appealed to the highest court in the land, it's over for you. You're supposed to just pack in a towel, throw your hands up, lay on that train track, because that light that's coming at you, it is a train, and there's nothing you could do. Well, Mark, being the rebel that I am, I'm also a very blessed guy, because when I was part of the reconciliation meeting for the legislation, they told me, well, Carnell, if it's anything you want to do here, it's going to have to happen in this meeting. And we are going to pass this bill today. Well, Mark, I rewrote and restructured that bill so that it helped the broadest group of paternity fraud victims. And I remembered I had another avenue to be able to go back in court. And I went back using the law that I was lobbying for other people. And I won. Mark, on February 5th, 2003, I walked out of court a free man.
Okay, so let's stop at that point. I know that's a very important point of your life. I want to backtrack just a little bit and just state what the hell was going on with the state courts, the federal courts, the Supreme Court, when you're showing proof that you didn't have paternity and that you should still pay child support. What was, I mean, they just didn't hear it, which is shame on our court system. And I know people listening to this that have tried to appeal. Some of us have gone federal, and we're feeling like, you know, the courts are rigged as a result of not hearing. Yours is cut and dry. I mean, some of the rest of them, there's some subjectivity to it, but clearly rights are being violated. So if they wouldn't even hear yours, which was crystal clear, what hope do they have? And that's a rhetorical question. But I want to get back to what was going on in the minds of the court. Or did you ever find out when you presented that crystal clear evidence?
So here's the thing. As you know, that when you try to appeal, if you don't win at the lower court, it disheartened me to find out you do not have a protected right to an appeal for family law. Family law has been reclassified as such that it is a discretionary appeal, which now means unless the court chooses to hear your case and grant certiorari, where you can come and then argue your position, you have no other way, because they don't even have to tell you why they're denying it. So if you wanted to submit a motion for reconsideration, you're in the blind, you're in the dark. So that holds true at the 2 state appellate courts. So there's a state court of appeals, there's a state Supreme Court, and then even with the U.S. Supreme Court, you don't have a protected right to appeal for family law. You do for criminal, but that was a stunning eye opener for me. And what I've learned in the process is then the way that you remedy the situation is you must limit or eliminate judicial discretion in matters like this, where it is you can provide a preponderance of evidence that doesn't need a judge to decide. Okay, well, you can look at the evidence and determine if the evidence is valid. You can have challenge on the evidence, but you do not get to just ignore it and say, well, look, we already got this court order. It's already in place. Hey, he didn't know that it was a con or a hustle for 11 years. Shoot, it's his fault he didn't figure it out sooner. But Mark, the same judge who was with me when my governor signed that legislation, he came to that legislation. He apologized to me face to face for his ruling. And he said his ruling was wrong and that he was glad that the law has changed. He stuck his hand out for me to shake his hand. And guess what? I shook his hand and I accepted his apology because he didn't have to be there, Mark. And I said, that says a lot to me if a man will admit he's wrong.
Yeah, but isn't that the exception and not the rule? And then what was going through his head when he made that original ruling? I don't know if you sat down and had a conversation with him, but to me, I'm disgusted by the whole thing. So I'm not the right person to ask.
Hey, I'm not real qualified on that one. The conversation was very limited. In fact, my attorneys had to spend about 5 minutes talking with me to get me to speak with him because he was not a person I ever wanted to see again in life.
But here's the thing, not a lot of us have the fight that you have. Do you think that guy would have gave 2 shits about you had you not put up this fight?
I'm not qualified to say, but I
will
will say
he wouldn't. The only reason that he did is because he knows you were calling him out on his shit. Well, it was shit.
Well, I will say this, that there are times that the law is wrong. There's time that the judges are wrong. And unless you have statutory law, which means now that in family court, just like everywhere else, the judge has rules that he has to operate within that parameters and not deviate for it without having to state by solid facts, by conclusions of law, and not just his own opinion. Judges are called triers of fact, right? And that's one of the things I told the legislature. If the judge is a trier of fact, and you have the mother herself admitting she knowingly and willingly hid material facts from the guy in order to induce the guy into believing the child was his. We should not be allowing the court to make a decision that evidence is not acceptable. And then add to that 2 DNA tests. The mother challenged my first DNA test, Mark. She said, something's wrong with your test because I did the first test with just myself and the child. Mark, a lot of people don't know it, but if you're testing for paternity, you don't need the mother. You need yourself and the child because you get half DNA from mom, you get half DNA from father. And if that child has 0% match for you, that is not your child. Now, for some guys, they're okay with that, and he'll make an informed decision to stay involved. But there are people like me who there was no lasting relationship with the child's mother. And the mother has now gone so far as to alienate me from the child, cut out my parenting time, interfere with my court-ordered days. So why would I stay under a court order when I get 0 benefit and I face jail and prison?
Right. And she doesn't, by the way.
And she's not even chargeable. She is not even chargeable for the fraud because you have extreme difficulty finding a prosecutor who will filed the criminal charge for fraud because it is definitely in excess of $1,000. So we're talking grand larceny on a very high scale.
Yeah. I'm guessing you could have filed a civil lawsuit against her, but I don't know.
I did file a civil lawsuit. But
let's quickly dive into that.
Well, here's the deal. Most guys are not aware of that until you can overcome that designation as legal father of the child, you don't have standing to be able to sue for the civil damages. And that's another stunning eye opener. So there's a lot to be said about what you need to do. So you can take actions for the recovery, for damages, the monies that have been wrongfully paid, loss of use for your money, emotional distress, anguish, because I know men who have been imprisoned over this. But you have to know how to navigate the process. It's like walking through a minefield. And man, without having a map of where the bombs are in that field, it is more probable than not you're not going to get out of the minefield alive.
Wow. Okay. So you filed a civil lawsuit. We don't have to go down that direction. That could be a whole nother call. Did anything result? Maybe just give us the result, and then we'll move forward.
Sure thing. The civil lawsuit and attacking the judgment for legal father was what I appealed and took to. That was what the trial court judge refused to rule on and just denied my ability to attack it. And that was what I appealed as I continue to progress through the various appellate courts. I even went so far as to attack the subject matter jurisdiction, and I used constitutional grounds, because given that there was no statute that says you can order a man who is not the adopted parent of the child and not the biological father of the child and not the man who participated in assisted pregnancy, in vitro fertilization, and all these other methods like surrogacy with his knowledge and consent. Well, I was in none of those categories. Then the judicial discretion should not apply. And my constitutional rights to what? Life, liberty, and the pursuit of happiness, and what protection of my assets, and protecting my wife and my newborn from becoming homeless. All of that should have mattered. And since I had given statewide data, I'd given national data by the time it reached the U.S. Supreme Court, I've proven that it is not a rare issue, and Carnell Smith is not the only guy that a woman or girl has lied to about the paternity of their child.
Okay. Let's get back to the case. So you win on, I think you said February 2003.
Yep. And you want to know what happened to that? What did I win?
Yeah. What did you win?
By using the legislation, I was there with 2 television cameras in the courtroom, and they declared that I am the first person to win using that law of House Bill, based on House Bill 369 in the year 2000, Georgia Code Section 19-7-54. It vacated all of the arrears that I hadn't paid. It wiped out all future payments. It included a court order to remove my name from all documentation as the child's father, and required the mother to get a new birth certificate reissued with my name removed and provide me with a certified copy. And she could not sue me for anything beyond that case, because I fully intended to write my story after that.
Okay. So, but did it establish case law?
Did it establish case law? Since I won at the trial court, and it's a trial court decision, I think you'd have to know to look it up and determine whether the fact patterns of the case. Actually, at this point, my case is irrelevant. Know why? Because I lobbied for and successfully got statute in place, and statutory law trumps case law.
Yeah.
So the strongest thing for a person to do is forget my case. You need to know how to file your case according to the new code section 19-7-54, based on House Bill 369 from the year 2000.
Okay. And that's federal?
That is state. That is the state of Georgia. And what's great about that is the state of Georgia and the state of Ohio are the only 2 states that have that legislation with unlimited time limits, which means as long as your case is alive and they can still enforce child support against you, you can attack that judgment once you find out what the truth is, if you're not related. And I've even had one client who won when he found out the 30-year-old kid and 33-year-old kid were not his from his ex-wife, and he went after her and he managed to get damages.
Wow, I love that. And so if you're not in Ohio, you're not in Georgia, let's say you're in California where I am. So how would could they use the precedents from Georgia, or is there a federal statute or?
Nope. So here's the thing. Family law is relegated to the states, which means you're controlling decisions for what happens in with family court, family law in your state is going to be based on what statutes are. Now, can judges look at trends in other states? They can look at it, but is it a controlling matter? Meaning, can you control using a citation of what happened in the other states? No. Listen, in California, we had actually gotten paternity fraud legislation passed. I'd worked with Assemblyman Rod Wright back in 2000 to pass the Paternity Justice Act with the Veterans Against Paternity Fraud, the California Citizens Against Paternity Fraud, Women Against Paternity Fraud. And we got it past the Assembly and the Senate. But when it reached Governor Gray Davis, he vetoed the bill when somebody told him that if he passes this legislation, they were going to lose more than $30 million in child support, incentive, and bonus money. So he vetoed the bill, and we couldn't get enough support to override his veto. So Governor Schwarzenegger come back a couple of years later, and he did pass a limited bill that was only good for 2 years. And the problem was, Mark, is that there was no notification required. So a lot of people, if you weren't in tune with the media, and this case applied to you, you wouldn't know that during that 2-year window, you could have attacked the judgment. So once it expired, there is no current legislation in California that will allow you to attack a paternity fraud judgment.
That's insane.
Yes, it is.
Let's just call it what it is and say it's how insane that is. And I know what they're thinking is, well, somebody's got to pay for the child. Okay, well, why would it be someone that's not their father?
Well, guess what? They never asked this question. And no, in every place I've traveled, by the way, we did get it passed in Florida, Oregon. I've testified in Wyoming. I provided model legislation to Texas, North Carolina, and several other states. I've improved on the legislation since I've gotten it passed. But here's the thing, Mark. None of the both houses in the legislative bodies are able to refute this statement. The child's mother is the only person who knows how many names are on that list during the window of conception. Why doesn't she have a moral, ethical, legal, and a fiduciary responsibility in the best interest of the child that she state accurately who helped her get pregnant? Because the guy is not going to know that unless he was an eyewitness to the impregnation. Did you get what I'm saying?
Yes, which is impossible anyway. Even if you're watching the act, you're not following the sperm hitting the egg. So
correct.
It's literally impossible.
Correct.
But there should be something in place. I'm all for privacy, but there should be something in place where she doesn't have to name a bunch of people, but she said she would be required to say if she had other potential partners that could be the father, and then the test is made.
Well, I'm with you. I've actually agreed. A woman who I came across in media, she's the founder of the Americans for Child Support Enforcement Association. She said these words that I took them and ran with them. She said that it was not fair to make a woman put her husband's name on the child's birth certificate when her boyfriend, who she was living with, was the child's father. Did you catch that, Mark?
Yes. Yes.
And I said, that makes perfect sense. But you have to know that there's 4 ways that men become paternity fraud victims to understand that. All right. One of those ways is the marital presumption of paternity, which means any children that the wife has while she's married to you, even if you are legally separated, even if you are deployed out of the country, which is why a lot of married men are victims. What if you are a traveling musician? You're doing concerts, promotions, you're touring the country. If she has a baby while you're out of town, In those states that uphold the marital presumption, you're automatically the father. And California is one of those states, as well as Texas.
Insane. And then so you got to rebut the presumption. And
no, you don't even get to rebut the presumption in those states. It is deemed a conclusive presumption, not a rebuttable presumption.
What?
Yes. So a few years later, I'd say probably in the 90s, maybe closer in the 2005 range, they put together this non-elected body of commissioners, and they created this thing called the Uniform Parentage Act. So this was supposed to address the paternity situation, right? So what they came up with is that, okay, well, we'll allow for some limited challenges if the men, for those states that did adopt it, men allowed to challenge paternity between the ages 2 and 5. So if the child's between 2 years old in some states and you figure it out one day after 2 years, you are conclusively trapped. The states that are the age 5, all mom has to do is be quiet a day past that time limit, and that guy is now stuck like Chuck. By the way, in that meeting with that non-elected body, no one said and put in that legislation that they presented for states to adopt. There is zero requirement for the mother to make a knowing and truthful disclosure. So what? She doesn't have to give a list to the guy, but she should be required to answer this question under oath. During the 60-day window of conception for your child, is Mr. X, who you allege the father, is he the only possible biological father of the child? Number 2, did you have any intimate relations with anyone else during that window? And she should have to answer those questions under oath. And number 3, then you do a DNA test to see if she lied.
I completely agree. Unfortunately, there's some advocacy groups that would have a conniption over that, which is unfortunate because, again, are we looking out for the kids? Or are we prioritizing the mother over the kids, which would, for me, would be shameful. But that's what's the current situation is.
Listen, France passed a law that says the guy can't even get a paternity test without permission from the mother.
Outrageous. But yeah. Good thing we're not France, but we're not far away from it. I know you did some great work.
In some states, yes. But that's why you need advocacy to bring about legislative actions to create statutory law in the best interest of children. Because, Mark, what good is me providing my medical history for a child that's not mine?
Yeah.
Doesn't help that child one bit, right? But it also leads to taking away resources from the household of the children that are his. And my greatest body of support, Mark, has come from women who are against paternity fraud, because they're tired of seeing 50, 60% of the net income go across town for children that are not their husband's kids, and they are not able to fully feed, clothe, and provide for the children that live in the house with them that are theirs.
It is interesting, isn't it, Carnell, that there are, and I know who you're talking about, and I see the support that you get. That once the shoe is on the other foot, how quickly things change. So now you have women against women that are doing this nonsense.
But that's how I always got legislation done, Mark, even before there was a Women Against Paternity Fraud 501c3 group.
But why do we have this legislation in place to begin with? Why are we having to fight, this crazy legislation that's not common sense? Now, I'm going to get to the heart of the matter before we close things up. Is it about money? It
is about money, because why does a mother go to the child support court in the first place? To get more money.
And then why do we have a willing actor in the government?
The state, look, you have a willing actor, you have the family court, you have the Office of Child Support Enforcement, and you have unlimited legal resources backing up the Child Support Enforcement Agency in the Office of the Attorney General. So if you're an individual going up against, literally, they have almost unlimited resources and they know the lay of the land. They know the case law. And if you're coming there unprepared as a pro se litigant, or if you're coming with a family law attorney who is not versed and up to speed, too many of people show up in court, Mark. If they do come with counsel, they bring in a negotiator. For paternity fraud, you need to come in with a litigator. You understand? They are not the same. They are not the same type of attorneys.
Agreed. Yes. And how unfortunate is that? And it's not like you have a right to that litigator. You have to pay for it.
Oh no, you better look. You better come up with funds. Listen, your right to an attorney, that only applies to criminal court. I've had guys tell me, man, I know my rights. I'm like, you poor guy, you're confused. I was like, look, now when they put him in jail, look, he can go to jail for not paying child support. He can get a the public defender long enough to get him out of jail. But then when he gets back to family court, he can be sent back to jail for contempt for not paying the order.
Unbelievable. Now, do you blame men and some women that pay child support? Let's face it, because they've created this game for themselves that's impossible to navigate if you don't have a legal background. And even if you do have a legal background, what's interesting is that family court attorneys don't do appeals for the most part. There's some rare animals that
very rarely,
because
very rarely.
All these games have their own rules and regulations and language. It's a game. It's a rigged game that they've constructed for themselves, and it boils down to money. And maybe we've got to have you back. I have an idea. We'll talk about that later.
All right. Well, just so you know, I had a good friend who was a criminal prosecutor attorney. He has multiple firms between Georgia and Florida, and he was a paternity fraud victim. After he found out his second wife couldn't get pregnant, that was when he found out he was sterile. So how did his first wife have 2 children? Because she had multiple affairs while he was married. Wow.
Okay, so wrapping things up, what policies, if you're a legislator and you're listening to this, do you recommend they adopt the Georgia policy?
Oh, I would absolutely. I would encourage them to adopt the legislation that would be a hybrid between the Georgia and the Ohio model. One of the things that we did was we made sure we put in place a way for those people to get a paternity test when the mother will not allow the guy to see the child. Because see, this ties into parental alienation as well.
Yep.
You can't get a DNA test on a child you can't see. So therefore, you can't challenge an order, even if she told you to your face.
Yeah.
Little Susie's not yours, and you better have my money or I'll have you locked up.
It's crazy. All right. One last thing. I want to make sure that the people, though it has to be men, listening to this, they're in a situation now, perhaps, where somebody is saying that they're the father, they have questions, or maybe if they don't have questions, what are the kind of the immediate things that they need to do if they're in this situation? Now, we've heard, DNA tests demand that, but if you don't have access to the child, that could be difficult to do. Is there a court order? Let me just turn it over to you and just say, hey,
okay,
you're listening to
this. I will say this.
Yeah, go ahead.
If you're listening to this, I'm Carnell Smith, the paternity coach. I help women, men, and families address the issues of family identity using DNA, law, and advocacy. And if you have questions or you've been told that you're not the father of a child and there is an existing court order, you're going to need some help in navigating that. So if you're going to be a pro se, pro per litigant, you're going to have to get skilled and up to speed and everything from how to properly submit evidence, know what evidence you need to collect so that when you do approach the court, that you at least set yourself on a level playing field to be able to do something about it. If you are in a state like Georgia, Ohio, Florida, Oregon, and those that have legislation in place, you still have to read the actual law so that you file according to it. You might need a coach. I'm someone who is capable, knowledgeable. I've written model law. I know my way through this process. I've worked with people pro per. I've worked with people who are represented by attorneys. And I've been in the DNA industry. I went into business with them for 10 years. So I know the DNA services. I know the options on what you can do to get the answers you need. And if you're interested in changing the law in your state, you're going to need more than just a copy of our law, because there are steps and there's a process that you got to go by. There must be something about what I did differently than everyone else, where we got the law passed in 1 year. And I know people who haven't gotten it done in 10 years. There must be something different about doing it the way that I did it. I'm Carnell Smith, the paternity coach. I invite you to apply to work with me at carnellsmith.com.
Wonderful. I was going to ask, how could people get a hold of you? Is there any other way besides your website, carnellsmith.com?
Yes. And you can also find me. I have my social media page. So I have a Facebook page. You can just search for the Paternity Coach. 2 words, Paternity Coach, or just put it together. Paternity Coach, Facebook, Instagram, Twitter, and YouTube. I have tons of videos where you can see internationally and nationally paternity fraud victims, including a young man who gave up a full ride football scholarship to go to work to pay child support and then find out the child wasn't his and he can't get his scholarship back. So just use Paternity Coach and you'll find me at Facebook, Twitter, Instagram, and YouTube.
All right. Now with that, if you're in this circumstance, there are some timing issues you got to be aware of. Reach out to Carnell, see if he can help, or just listen to this over and over again. Carnell, I want to thank you for being on the show, and I've got an idea for another episode for us that we'll talk about later.
Okay. Well, look, also let them know there's a great resource available on Amazon now. I've written an ebook and a paperback. It's called Trapped by Law: Stop Paying Child Support for Paternity Fraud. It hit #1 bestseller in 3 categories, including law, during the pre-order phase. So that means there's an interest and there's people who want to know how to get out of being trapped.
Thanks again for tuning in. A reminder that we are not attorneys and this is not legal advice. We advise you do the research yourself or to contact an attorney you trust. There are very few of them. This was Divorce Matters Podcast.